Welcome to today's episode of your favorite channel, Law and the People. My name is Barrister Nnenna Okereke. Today we will be discussing a very interesting topic, the concept of bail. Bail is a core aspect of the Nigerian legal system. It is a system in Nigeria whereby a person alleged to have committed an offense and for which he has been arrested is set free, subject to certain conditions. I want you to note that the grant of bail, as well as its administration in Nigerian legal system, is regulated by the Administration of Criminal Justice Act 2015 for federal offenses and the Administration of Criminal Justice Law of various states in Nigeria. If time permits us, in this episode, we will examine the entirety of bail administration in the Nigerian legal system. Let's look at the purpose of bail. Although the main objective of bail is ensuring the subsequent appearance at the place and time agreed, it also serves as protection against wrongful detention while investigation and trial are on course. Therefore, bail is a basic conditional right guaranteed by the Constitution of the Federal Republic of Nigeria, 1999, as amended. It is predicated on the constitutional presumption of innocence of an accused person until proof of the contrary is obtained or achieved. Thus, while the Constitution guarantees the right to personal liberty, the right may be derogated from in the following circumstances as provided in Section 35, Subsection 1, Subsection C of the 1999 Constitution as amended. The circumstances as follows. 1. For the purpose of bringing the suspect before a court in execution of the order of the court. 2. When it is reasonably suspected that the suspect has committed a criminal offense. And the last, in order to prevent the suspect from committing an offense. However, as provided in Section 35, Subsection 5, Subsection C of the 1999 Constitution as amended, in the event of this derogation, the suspect arrested must be brought to court within a reasonable time, otherwise he should be released on bail. Let's look at instances where bail may arise. The grant of bail arises at 3 stages, namely, 1 is police bail pending further investigation. The second one is bail by the court pending the determination of the case against the defendant, and the last one is bail by the court pending the determination of appeal against conviction. Let's take these instances one after the other. First is the police bail. Section 62 of the Police Act 2020 gives the police the right to grant bail to a person taken into custody for an offense not punishable with death penalty and which cannot expeditiously be charged to court, especially if arrested without a warrant. However, where the offense allegedly committed is serious, he can be detained for more than 24 hours but must be charged to court as soon as possible. See Section 62, Subsection 3 of the Police Act 2020. Thus, by Section 63 of the Police Act 2020, where a suspect is taken into custody and it appears to the police officer that the inquiry into the case cannot be completed immediately, he may discharge the suspect on his entering into a recognizance with or without sureties to appear at the police station and at such time as are named in the recognizance. Bail at the police station is free and it lapses when the suspect is arraigned in court. Let's look at bail pending trial. Courts are also empowered to grant bail pending the determination of the case. Thus, Section 159, Subsection 1 of the Administration of Criminal Justice Act 2015 provides that where a suspect or defendant is detained in a prison, police station, or any other place of detention, the court may issue an order to the officer in charge of the prison, the police station, or other place to produce the suspect or defendant at the time and date specified in the order before the court. However, the powers of the court to grant bail pending trial depends on the type of court and the nature of the offense. Let's look at bail pending appeal. Here, the accused person must have been convicted and sentenced to a term of imprisonment or a fine. When this happens, the accused person loses his freedom until the expiration of the term of prison or the payment of fine. However, where the convicted person has appealed against his conviction and awaiting the hearing of the appeal, the court may grant him bail. The grant of bail to a convicted person pending the determination of the appeal is at the discretion of the court. Unlike bail pending trial, which is a constitutional right secured by Section 36, subsection 5, and Section 35, subsection 4 and 5 of the 1999 Constitution, bail pending appeal is not a right, but a privilege. This is true because after the conviction of the accused person, both constitutional presumption of innocence and right to personal liberty are gone. The concept of bail is enormous and cannot be exhausted in this session. On the next session, we will look at the types of offenses and the cause that can grant bail to them and the cause that cannot. Until then, keep watching this channel. Like the videos. If you have any question or comments, do let us know on the comment section. Click on the subscribe button and the bell icon so you'll be notified each time we are online. Thank you for watching and remain a law-abiding citizen. Thank you.